Thank you for watching the Momentum Men's Ministry on demand page. Today, you will hear a message from Michele and Kisha on estate planning, wills, and elder law. Now, prepare your hearts and minds for the scripture and the messages for today. Enjoy. The scripture for today comes from Joshua chapter 1, verses 7 through 9. Be strong and very courageous. Be careful to obey all the law my servant Moses gave you. Do not turn from it to the right or to the left, that you may be successful wherever you go. Keep this book of the law always on your lips. Meditate on it day and night, so that you may be careful to do everything written in it. Then you will be prosperous and successful. Have I not commanded you? Be strong and courageous. Do not be afraid. Do not be discouraged, for the Lord your God will be with you wherever you go.
So I'm certainly delighted to be with you. I've heard such great things about this Momentum's Men's Gathering. So it's certainly a pleasure to be with my fellow brothers in Christ. I feel just a little bit slighted because I'm having to do this virtually. Like, where are my eggs and bacon and biscuits? But it's certainly a joy to share this information. Kisha and I are both passionate about it. So it is a pleasure for us. And I certainly consider this part of my practice as ministry. So, first question for you is, does everybody have an estate? And I can't see you while I'm presenting. So you can just jump off from being mute for a second. And anybody answer the question, does everybody have an estate?
Yes.
Yes.
Yes, yes. Everybody has
Yeah.
an estate. And your estate is the property or the assets that you own. So it's your car, it's your house, it's your bank accounts, it's that old antique car that Papa left you. You have an estate. And oftentimes when people hear the word estate, they're thinking of people of high net worth, but it's everybody who owns anything. And when we're talking about estate planning, we're just not talking about assets or things. We're also talking about your health and what should happen if you should become incapacitated. Who's going to step in and make those decisions for you on your behalf according to your value system? We're also talking about if you have minor children or a special needs adult child, who's going to be in charge if something should happen to you, and if you're married, should happen to you and your spouse. Also, estate planning is a way to minimize expenses and in some circumstances to minimize taxes. So it covers a lot of areas. And there's a scripture in Proverbs where Solomon, one of the most wisest that lived among us, talked about being diligent. Believe it's Proverbs 21:5. And the diligent person, or the one who plans, they're thinking about, what am I going to do with these particular assets that God has given me? So estate planning is also about stewardship. Think about the burden that you're relieving your family from if you just put some things in place. So not only is it an act of stewardship, it's an act of love as well. So let's get to it. So these are some of the things that estate planning allows you to do: to leave a legacy, transfer assets and wealth, and preserve your values. One, providing support and financial stability for your family. If you provide significant income to your family, what's going to happen if all of a sudden your family loses that income? So just think about that for a moment. How will that impact your spouse, your children, their futures, etc.? Also, it allows you to leave assets for future generations. So you can leave assets for your children's children, even children you don't know about yet. You can plan for them and leave a legacy. Oftentimes I see in certain communities where it's like each generation is starting over. And wouldn't it be great if we would start thinking about leaving a legacy so that our next generation, they're not starting over? Also, you want to ensure that your assets are distributed according to your wishes. So it breaks my heart when someone is coming into my office after someone has passed away and they say, oh, my brother and my dad, they wanted this to happen. I understand and my heart goes out to you, but because there was no plan in place, the law steps in and we have to do it according to the law. So we talked about estate planning allows you to minimize expenses, minimize taxes if possible, make known your medical wishes, and preserve your values. So there are several different tools that we use when it comes to estate planning. So we'll talk about wills and briefly, trust, powers of attorney, etc. So the first one is a will. So everybody needs a will. I won't ever tell you, let's see, you only have this, so you don't need a will because I don't know what assets you might accumulate in the future, and you don't want that asset to be fall under intestacy law. So intestacy means you pass away without a will, and then the law steps in and says this is how your asset will be distributed. So it's a legal document. It names who will receive your property when you pass away. You can also accomplish the following in the will. You can appoint your executor. This is the person that's in charge of administering your estate and ensuring that your assets go according to what's in your will. And then you can also designate a guardian for your minor children. If you are the children are the parent of minors and you're the surviving parent. So that's what you accomplish with the will. Let's talk about a couple other tools. We have a trust. In your trust is an arrangement where you own the property while you're living. Most of the time we're talking about living trust, but there are several different types of trusts. For example, special needs trust if you have a special needs loved one in your life. But here, when I'm talking about a trust, I'm speaking of a living trust. You have that trust active and you're managing it while you're living. And then you're managing it for the benefit of someone else. So while you're living, you may be the beneficiary of that trust. And then when something happens to you, then maybe your children or your niece, a nephew, or brother, or significant other is the beneficiary. But it's being managed for them on their behalf. So sometimes people come in and they say, well, what do I need will or trust? It really depends on your situation. Everybody's situation is different. It depends on the type of assets you have. It depends on what you want to accomplish. It also depends on your family dynamics. So if you have let's say an interesting situation as far as family dynamics and you don't want your estate going to probate, the trust may be the way to do it. So when I mentioned the word probate, when you hear that word, that means that's the legal process. We're going to court, and that's the legal process where we're transferring title of your assets from your estate to the beneficiaries, heirs, etc. So you can stay out of court if you have a trust and you properly maintain the trust during your lifetime. The other tools are powers of attorney. So you're authorizing someone to act for you. Another thing that breaks my heart, someone brings their parent into my office and say, she really needs a power of attorney. We can't help her. We can't do anything. And the parent is already incapacitated. We cannot prepare documents for someone who's incapacitated. So you have the privilege and the benefit to do it while you have the capacity. So this person, for your statutory durable power of attorney, what we call it in Texas, that's your financial one. This is the person that you appoint to act on your behalf should you become incapacitated. The medical power of attorney, the person you appoint to act on your behalf to make medical decisions for you should you become incapacitated. Keep in mind, the power of attorney is not valid when someone passes away. So I'm pretty sure with the number of people on this call, there's somebody who knows I had a loved one pass away. I went to transact business at the bank and they froze the account. Yes, because that power of attorney is not valid when someone passes away. And I actually don't mind if you interject questions while we're on the topic, but I can't see you, so you'll just have to holler it out. A couple other tools for your estate plan is the Health Insurance Portability and Accountability Act authorization. This is the HIPAA form. So with this HIPAA law that was put in place many years ago, it protects one's privacy as it relates to their health records. So if you want a loved one to have access to your health records, this is, you're incapacitated, you can't give them the approval to do so, then you would do it in advance, name who your agents are. So let's say you want both of your children to be able to access your medical records because you want them to be able to look at that last x-ray, to look at previous history so that they can make an informed decision. Then they would need to have the authority to do that. Next is a declaration of guardian. Hopefully with your powers of attorney in place, you would never need this. But if you have powers of attorney in place, in the unlikely event you do need a declaration of guardian, this is the document where you are naming a guardian who will take care of you should you need a guardianship. A guardianship is when the courts are involved and you're having to, someone is having to act as guardian over you because the person has become incapacitated.
Michele,
yes.
You have a question in the chat. The question:
Okay.
If the power of attorney is inappropriate after death, what is the best way to have immediate access once death occurs?
Yes. So as I was saying, power of attorney is not valid when after someone passes away. If you don't, if your name is not on that account will likely be frozen. And it depends on what you're going to have to do with that estate in order to get access. It will not be immediate because there's some process that you're going to have to go through in order to get access to that account. There are ancillary procedures in Texas that are offered where you can, you don't have to do a full what we call an administration, where you get appointed administrator, and then you have to go through this process, go through a hearing, all of that. There are some ancillary procedures, but that estate would have to qualify for it. But no immediate access is something that's going to have to be done if your name is not on that account or if you were not named as beneficiary on that account.
Yeah,
Michele.
one more question.
Oh, go ahead.
You have one more question in the chat. Do you need a HIPAA authorization if you have a medical power of attorney?
So in the medical power of attorney that I draft, I do include like a HIPAA component in there. If you want more than one person, more than the person that's acting as an agent, to have access to your records, then you will need that other person's name on that HIPAA authorization.
Michele, question for you. When does the executor step in?
So an executor is named in your will, but officially authorized to act on behalf of the estate once a will is probated. Just to give you an example, a lot of times, this has happened a lot where someone will come in and say, well, I'm the executor in the will and the bank won't let me do this, or the insurance company won't let me do this. Well, you haven't been officially named by the court. So when you have a will, it doesn't mean that you don't have to go through probate court. Depending on what's in your estate, and if it needs to be probated, then you will have to go through court and get officially appointed and ordered by the state, by the court, as the executor. When you have a will, if a valid will that's properly written, well written, straightforward process. We file the application, have the hearing, you're appointed, and then you can go do whatever, take care of whatever business you need to take care of. Without a will, much more costly, time-consuming process. We have to have two court proceedings. They're back-to-back, scheduled back-to-back. But one, we have to determine who are the person's heirs. Because yes, even though you say, oh, everybody knows I was married to this person and I have 2 children. Yes, but if you don't have a will, and we have to do some administration on your estate, the court has to be sure that all the heirs are accounted for. So there's a whole nother court proceeding that has to take place.
Thank
Good
you.
morning, Michelle.
Good morning.
This is Tim Whetstone. Question:
Hey.
how often should one update their wills?
Good question. I actually have a slide that's specifically for that. So let's put that on the parking lot for a second, and I'm going to address that question, Tim.
You have a couple more questions in the chat.
Okay.
Property remain in the state. And then the second question is, what determines while you're still competent?
Okay. The first question, Kisha, I didn't hear because it went out for a second.
Oh, no problem. The first question was, how do you properly maintain an estate?
How do you properly maintain an estate? Okay, I'm not sure if I would be answering this correctly because I'm not sure of the question. So generally, when we're talking about an estate, if you're talking about an estate you're living now, and I'm talking about the things in your estate, you would just, maintain it as you would from day to day as you do now. Now, if you're talking about an estate when someone passes away and you're responsible for maintaining someone else's estate, you want to make sure that you're keeping everything status quo. Like if there is a mortgage on the property, make sure that that mortgage is getting paid so that it doesn't go into foreclosure or something like that, or you don't have complications with the bank. If, there is a leak in the house, make sure it gets taken care of. You just want to maintain everything, keep everything status quo until property gets distributed. And the second question, was there a second question?
Yes, the second question was, how do you determine what's the determining factors for while you're still competent? So what does
capacity? Yes, yeah. So your doctor, so the lawyer is not making a decision on your capacity. Your family member is not making a decision on capacity. It's your doctor. So if your doctor has made a decision or has, said, this person has, Alzheimer's, they can give you paperwork to say it's at this stage and this person should not be making decisions. They can't contract at this point. So that's certainly a decision that is made by your doctor, not by lawyers or family members or anything like that. If you are in a situation where you have a family member and you think that they are at that point, you want to start thinking about how you're going to care for them and making sure, you have the proper documentation from the doctor as it relates to their level of capacity.
Let me just interject here because I know that there's more in Michelle's presentation, and I see a lot of people have questions. I'm sure some of the questions may be answered as they keep going, and then Kisha. So let's try to save some of the questions till after. I understand that people are sending stuff in the chat, and then we can address those because at this point she may not get through her presentation.
And another thing, I don't mind staying over a few moments to answer questions. So I will hang out afterwards and then answer questions as well.
Because I know that this is a topic, that a lot of people are interested in here, but let's allow them to go through their presentation and then we can try to address some of those questions afterwards. Because I just think that
I agree with Tom. Let's keep putting our questions in the chat and we'll come back and address those later.
Okay, sounds good. Okay, number 6, the advance directive. You're telling your physician, family, and friends what type of extraordinary treatment you want or don't want if you are terminally ill, seriously injured, etc. This is when death is imminent and you have in advance put in writing what you want to happen so that your family is not having to say, do we take them off the machine? So that burden is taken off of them. Transferring documents like deed. Think about when you buy your house. There is a deed involved that's recorded in property records. So you can deed property to your loved ones. This is real property, real estate. Deeds have to be done properly. So I always recommend, please just have an attorney. If you're a do-it-yourselfer, have an attorney review that deed to make sure that it's properly done. And then understanding, the consequences of that. If you deed a significant house or something to a loved one, there's going to be a tax hit for them. So things like that to think about. And then appointment of agent to control disposition of remains. So if it's not as straightforward, if your family dynamics are unique and you want to appoint someone to be in charge of your remains, you can do that in this particular document. Also, if there are special things, like I want to be an organ donor, it's on my license, but I'm putting this in this document as well, because I want to make sure that everybody knows this is what I want. If you want cremation, for example, and your loved one is saying, I don't believe in cremation, but you want it, make sure you get it in this document. So let me, a couple key points when it comes to your will. This is so important. Keeping your original will in a safe place. When a copy is brought to our office, well, let me just say what the law presumes. The law presumes that if we cannot find your original will, you revoked it, meaning you did not no longer wanted it, you tore it up, you threw it away, etc. So we have to go through an extra process in court to prove that a copy of a will is indeed what you wanted. And then keep your other documents in a safe place and let someone know, the person you trust, let them know where those important documents are stored. So I want to do one scenario because I encounter this so much, and we'll quickly go through it. So H means husband, W means wife in this scenario. So H has a blended family, dies without a will, and also failed to update a life insurance policy. What happens? So in this situation, husband and wife are married. Husband, H, has a child from a previous relationship. Wife has a child from a previous relationship. The reality is we deal with blended family all the time. A lot of us are blended families. And then they have children. So the issue is, what happens if this person dies without a will, if the husband dies without a will? Well, you have the residential home. You would think that the home automatically goes to the wife. No, it does not. In a blended family situation, the wife keeps her 50% interest in the home. We're in Texas, a community property state. She keeps her 50% interest. The other 50% goes to the other children. So let's say this was a really close family and husband treated wife's child from the previous relationship just like he bore that, like that was his biological child. He would have wanted, if they had decided, okay, children get, so much of the house, he would have wanted that child to also receive. But under the law, that's not what happens. Only the biological child receives. And what if he just wanted the whole house to go to the wife? It's not going to happen when it's a blended family. So because I encountered that so much, I just wanted to do that one scenario. We're going to just jump down to, we're going to skip this one. And this goes to your question, Tim. This is when you want to review your estate plan. So when you have a significant change of event in your life, for example, a marriage, divorce, birth of a child, acquisition of new assets, when you relocate to another state, keep in mind estate law, probate law is at the state level. So the laws are different in Texas than they are in Louisiana and so forth and so on. So when you relocate, you want to revisit your estate plan. When a beneficiary passes away, you want to revisit it. Your health conditions change. If you have an increase or even a decrease in your assets, you want to think about it. And if you have started or ended a business. So you business owners out there, I hope you're having a conversation. If you want that business to continue on after you pack up your tent, I hope you're having a conversation about business succession. Don't assume if it's a family business that, oh, my family they're going to want to continue the business. Don't assume that. Have the conversation so you can put things in place. And then this is my last slide, and just want to emphasize this. Avoid these top 10 common estate planning mistakes. Not having one at all. But I do say, okay, if you don't have one, then actually you do, because the state determines what happens with your property, and you probably don't want the state telling you what you should do with your property. Not planning for incapacity, it could happen. And people start thinking about estate planning when they turn 60, 70. No, when you have assets, when you have minor children, I want you to think about estate planning. Attempted to DIY important documents, do it yourself. I get it. You know, you do your research, you're that person, you're diligent, all of that. But please just have an attorney look at it, because there are so many dynamics. So you go online and you go through one of those online services. They're asking you questions, but they don't know your family dynamics. They don't know what may be unique about your situation, or something's unique about an asset where we want to think differently about that. So please just have it reviewed. If you're going to be a do-it-yourselfer, have it reviewed. Leaving property to minors. You cannot leave property to minors. So what happens is you have an insurance policy. You have your child's name on it. She's 16. Something happens. You pack up your tent. She's 16. She cannot get those funds. A guardian would have to be appointed in order for her to get those funds. The guardian would maintain that property, use it for her benefit until she reaches 18, and then she could get access to those funds. Depending on people to do the right thing, no. Don't say, I'm going to leave everything to my oldest child. He or she will do the right thing. Please don't do that. Leave your property to whoever you want to leave it to. Make the oldest child your executor if that person has that skill set, which goes to the next point, choosing the wrong executor. Don't choose something because you feel a moral obligation, like the oldest child. If that person does not know how to balance a checkbook, don't make that person executor. Choose the one that they don't have to have an MBA or PhD, but choose the one that's, organized, that handles their business, pay bills on time, things like that. Failing to fund a trust. So sometimes we'll make this really nice, beautiful trust, and then the person doesn't put the assets into the trust. Neglecting to transfer real estate after a divorce. Look, divorce happens, God bless you both, but don't forget to transfer assets after a divorce. And failing to update your estate plan. And number 10, procrastinating. So I will hand it over to Lakeisha. And before I do that, just keep in mind, Proverbs, Solomon said, a good man leaves an inheritance for his children's children.
Today, we'll be going over just a general overview of elder law. Each of the topics that we're going to discuss this morning could probably be whole presentations in and of themselves. So please remember just kind of a basic overview, kind of the nuts and bolts, so to speak, of the topic. So we're going to Social Security benefits, just the retirement benefit. Social Security, something like 20-something programs that they offer benefits for. So we will just be about Social Security, the retirement benefits. We'll go over IRAs, or individual retirement accounts, or individual retirement plans, Medicare and Medicaid, the over 65 property exemption. I'll kind of follow up and discuss some incapacity issues Michelle's already touched on. Powers of attorney, but we'll discuss some other issues as they pertain to elder care. And in addition, we'll talk about some bank accounts and safe deposit boxes. So Social Security benefits, as far as retirement is concerned, are going to be the amount of Social Security you mainly depends upon your age at retirement, the earnings during your lifetime. So many of you will receive reports period. Some of you may receive them every quarter. Some of you may receive them every year, but they generally show you what your work history has been, and at different points of time how much you earned for that particular year. So your benefit is calculated based on earnings that are being contributed. Those that are self-employed and you're not contributing or not paying taxes, your Social Security will be affected by your lack of contributing to Social Security tax. So just keep that in mind. And if something, you can speak with someone, an attorney or financial planner, to help you rectify that. The calendar date of your retirement is also it's also determined upon when you're getting out when you're sorry. It is also the calendar date of your retirement is also a factor that goes into your determining your benefits. Offsets of retirement benefits. So if you work for a government or you have a government position, some of those retirement plans, like teacher retirement, things of that nature, also determine your factors as it benefit you that you receive Social Security. All right. So you may be asking yourself, who will receive Social Security retirement benefits? While these are mainly the benefits that are received while we're alive, not benefits at death. We will discuss that shortly. But your spouse, your current spouse, can receive spousal benefit. Your former spouse can your spousal benefit as well if you have a marriage that has lasted in consecutive years with your former spouse and they are still single. So your former spouse is entitled to some of your Social Security benefits. Your minor children and your disabled adult children can also receive benefits from your account as well. Now, your current spouse has to be at least 62 years of age in order to receive the spousal benefit. And if they claim a benefit prior to age 65, that benefit will be reduced, and that reduction is permanent. Okay, so and these, whether it's your current spouse, your former spouse, your minor, disabled children, their ability to receive what we call auxiliary benefits does not affect your particular benefit. And generally, these benefits are about half of the amount of your check. Now, Social Security benefits and divorce. If you were previously married, as I discussed before, you have to have been married for 10 consecutive years. Your former spouse has to be single in order to receive those benefits. But these also apply for if you're divorced and you were previously married. As long as that marriage lasted for 10 years, you can apply for benefits from your spouse as well. If you've had more than one marriage, so let's say, for example, you had a marriage that lasted at least 2 years, you divorced, you remarried, and that second marriage maybe ended and your spouse passed away. In that particular instance, the surviving spouse is still entitled to receive spousal benefit. And you can pick whichever benefit is higher, so whichever benefit would benefit you more. Now, you also have to keep in mind that when you receive these benefits can be reduced by your own Social Security benefit. It can be reduced by any other retirement you have out there. So if you have a teacher retirement or some other retirement income that you would be entitled to receive, that spousal benefit can be reduced by that as well. And just so before I move on to the next slide, just so if you are trying to get Social Security benefits under a spousal benefit, the only thing that is required to apply for benefit is you need your spouse's Social Security number. If you don't have their Social Security number, you will need their date of birth and their parents' name. So upon your death, the Social Security benefits that we've talked about, at death, if your current spouse can receive their death benefit as long as you were married 9 months before the death of the benefit that you're trying to receive. You need to be at least age 60. If you are disabled, you can seek that at 50 or older. If you are a widower or widower caring for a disabled adult child or minor children, there is no age limit. You can apply for that benefit and not have to really worry about the penalty for getting the retirement benefit early. And if you are divorced and about the same 10-year requirement still in place, and you're generally speaking the widower or widowed person, would need to still remain single. Now, there have been some recent changes with regard to IRA, and with IRAs, there's a mandatory withdrawal period. That mandatory withdrawal period was about 7 for most plans, and so when you turn 70 and a half, you have to start taking minimum distributions. And if you don't take those minimum distributions, there are heavy penalties and taxes that you'll pay on top of, the regular taxes that you pay when you receive these distributions. Now, that mandatory withdrawal has been reduced, or changed rather, I should say, where you now, that is now calculated based on life expectancy plus 10 years, and then that's recalculated every year. And with regard to leaving your spouse as the beneficiary of an IRA. Now, if your spouse has not reached retirement age and they roll over their IRA into an IRA under their own name, they can receive penalties for early withdrawal. They can remain in that kind of beneficiary status and receive their distribution under you. And so that may be a good idea depending on your particular situation, but that's something you would need to talk with an attorney about so that you guys can kind of help properly do that plan. Most of the time, you want to work with an attorney who is familiar with this particular area and maybe a financial planner so that they can kind of tag team and talk about the tax benefits in more detail as well as the legal benefits and marry those two things together to come up with the best option for you and your beneficiaries. If you decide to designate someone other than your spouse, say you want to designate your children or grandchildren as beneficiaries of an IRA, this could be a good idea depending on your particular situation and depending on how you're structured. If you do leave a non-spouse as a beneficiary, there is the potential to have what is called an inherited IRA. Now, these inherited IRAs are divided up. And it essentially creates one IRA for each beneficiary. So once you pass away, you've named your beneficiaries, and they're not your spouse, they can have these inherited IRAs. They can be managed. People can take their distributions. It allows you an opportunity to sometimes, in some cases, have another stream of income, sometimes for these beneficiaries' lifetime. But they, generally speaking, they don't have the mandatory minimums that they take. There are some time frames where they will need to take, they will need to have those distributions or start taking those distributions. So that time frame is generally about a year after you pass away. But they don't have some of the tax penalties as, say, your spouse would if they were to withdraw before they reach retirement age. And just to kind of piggyback off of what Michele was saying about leaving assets to minors, if you do designate a minor as a beneficiary, as Michele discussed, that minor cannot legally own property. So somebody would have to step in, that whether it's that person's guardian that's been appointed by the court or it's been placed in some other account. They're not able to access it until they reach the age of majority, which is generally 18. So you want to keep that in mind if you are thinking about leaving assets to a child or potentially a grandchild. With Medicare and Medicaid, I'm not going to go over Part A, Part B, Part D. I'm not going to go through that because each one of those could be presentations in and of themselves, but I'll give you some general overviews. So deadlines to apply for Medicare and for Medicare. Now, you have about a 7-month time frame. You have 3 months prior to your 65th birthday and 4 months after your 65th birthday. If you've missed this deadline, There is the what we consider open enrollment period every January to March of every year. Now, one of the things to keep in mind, if you have not reached age 65, you want to make sure you mark this on your calendar so you don't miss this deadline. Because if you do miss this deadline and you apply during that open enrollment period, there are penalties that are assessed for every year that you miss this deadline. So every year beyond either the 3 months before or the 4 months after. So once that 7 month period has expired on you, there are penalties, and most of the time those penalties are permanent. So you will continue to pay those. Other qualifications, for Medicaid, or for Medicaid, your qualifications. So Medicaid is the insurance that you receive for long-term care. So Medicare is the insurance you are more traditionally used to receiving when you are working. So, just like your regular checkups, those sorts of things. Medicaid is for the long-term care. So if you need nursing home care or in-home care that is going to be long-term, those things would be under Medicaid. So with Medicaid, it's means test. It's based upon a means test. What that means is essentially they're going to look at your income, your assets, your liabilities, and make some sort of an assessment. Usually there's a poverty line involved, and they will determine your needs based on that. So when you're talking about qualifications for those who receive other governmental assistance programs, they use sort of the same type of test. You must be a U.S. citizen. The Texas Health and Human Services is the agency that administers Texas of this Medicaid program. And so you have to be a Texas resident in order to participate in the Medicaid program in Texas. You have to be over 65, blind or disabled. Medical necessity. You have to have a medical necessity for either nursing home care or some type of licensed nursing care. That nursing home care can be in the home as well, other facilities like assisted living facilities. So you no more than about $2,300 a month in income for single individuals and $4,600 a month for couples when you're applying for benefits. Now, there are some things that you need to keep in mind with regard to when you are applying for benefits, what has to be disclosed to your caseworker, things that may be. Your caseworker can assist you with some qualification measures, but it is better if you educate yourself on what is included and what is not included when they are assessing your income and your assets. You want to make sure that they're doing what they're supposed to do for you. Now, the Medicaid Estate Recovery Program, this is a program that allows Texas to recover the cost of Medicaid services from estates from some people who receive services after March 1st of 2005. We often hear that my mom or my dad or whomever applied for a benefit, and now the state is coming after the house, or I have to pay all this money back. I received a letter from the state that says they're owed, money. Well, that is all the part of Medicaid estate recovery. And a lot of people are wanting to figure out how to go about planning around that. And some people, even because they don't understand how to plan for it, some folks just say, you know what, I don't want to do Medicaid at all because I don't want them to come back and take my house. I want to leave that house for my children or my grandchildren. And I don't want to put that asset, have the asset at stake for the state to come in and take it and sell it when I pass away because I've received this care. Well, there are things that you can do, okay? But generally speaking, Texas will not ask for reimbursement if you still have a spouse living. There's a child under the age of 21. If you have a child who is blind or permanently or totally disabled and they are receiving Social Security benefits, The value of your estate is $10,000 or less. The amount of the Medicaid cost is $3,000 or less. There is an unmarried adult child who lived in the home full time for at least 1 year before the death of the person who received the Medicaid. The cost of selling the property is more than what the property is worth, or there's some sort of undue hardship on the heirs. Texas can consider hardship to be if the estate property was used for a family business. Say, for instance, there's a farm or there's some family business that was operating out of the property, and if they took that property, it would cause that business to close or significantly impact that business. Or the heirs would need financial help from the government if the Medicaid recovery program steps in to remove that property or seek repayment of their funds. And so a lot of times people ask, well, can this amount be reduced? Is there anything we can do? Can we negotiate it down like we would any other debt? If the estate has debt such as funeral costs, legal costs, mortgages, those costs are paid before Medicare comes in and receives their claim or their claim is paid. If you have someone who has spent money on maintaining the home while the person receiving the Medicaid benefit was alive, so let's say there's a home that there were some modifications that needed to be made to the home to make it more accessible for the person receiving Medicaid benefits, whether that's installing some sort of a ramp or rail bars or upgrading or remodeling a bathroom or a kitchen to make it more accessible for the person living there, and helping whoever may be living there with them provide the care. Those costs can offset the amount that Medicaid wants to come into their claim, essentially, that they want to recover. So you just have to be knowledgeable as an heir and say, okay, well, these were the amounts that I spent. This is the remodel that occurred. This is how much it cost us. So we're asking for a reduction based on this. You will need to keep very detailed records. Receipts are going to be very important if you are going to ask for a reduction based on upgrades or changes or modifications to a qualified home. Maintenance costs such as real estate taxes, utility bills, insurance, home repairs, home maintenance, lawn care. Again, those generally can be used to reduce the amount that Medicaid will cover. Again, you will need to make sure you make receipts so that you can make a claim for that reduction when the time occurs. Direct payment for care. So let's say you're the main caregiver for someone receiving Medicaid, but you have to step out to take care of other business or you need to go to work. And so you hire someone to come in the home and sit with your loved one while you're away. Those costs can be deducted from the amount that Medicare can recover is under this program as well. Again, receipts and records are going to be paramount. Many times, this is up to the next slide. Many times people will want to figure out, well, how can I plan around this? What can I do? And those who try to do it by themselves or get information from other folks who say, oh, well, I went through that and I did this, will most times find themselves in situations where they are going to be penalized for doing it the wrong way. Okay. Medicaid has a 5-year look back, 60-month look back period. So when you're applying for Medicaid benefits, any transfers that you have made, selling of any property or other assets, they are going to review those transactions. If you do not make those transfers for what we call good and valuable consideration or fair market value, those transfers can be used as penalties against you. Okay. And when we're talking about a penalty period, you are going to pay whatever should have been paid for that penalty period. So you're going to pay a penalty until that penalty period expires based on based on your transfer and not doing it properly. If you work with an attorney to do it, you can do things as far as saving your home, as long as you use the right tools. Michele alluded to some of those tools when she talked about deeds. There are certain deeds you can do, like the state deeds or ladybird deeds, or some people have referred to them as, and those will protect your property from it. You can do deeds upon death. These will protect your property from this Medicaid recovery program, because mainly the Medicaid recovery program, they recover based on things being submitted to probate. If you avoid the probate process, most of the time you will protect your property and your assets from the Medicaid recovery program. So the moral of the story is if you understand or work with someone who understands this recovery program, and you plan, and have that plan written out, you will probably do a really good job of protecting your asset from this program. The over 65 exemption, so individuals 65 and over are allowed to have a $10,000 exemption in addition to the exemption that all homeowners receive, your homestead exemption. Now, if you do qualify for the over 65 exemption and say you qualify for another exemption, whether it's a disabled homeowner or a veteran exemption, you will have to choose between the over 65 or the disabled homeowner exemption. You should check with your school districts and some of those smaller agencies outside of the county, because they may have different rules may apply, and you may be able to take both exemptions in some cases. And most of the time, there are some situations where veterans can take 100% exemption or combine exemptions to take 100% exemption. So check with your local school district taxing agencies once you hit that 65 mark to see what options are available to you. And then some of these agencies will have maybe an additional $3,000 exemption. So instead of just receiving the $10,000 that you would receive, sometimes combined with the $13,000 exemption. It is important to understand. You can go to the next slide, Michele. Sorry. It is important to understand deferring your taxes, and having the exemption is going to reduce the amount of tax you have to pay. But there are some times where people say, okay, well, I'm on a fixed income. I don't have the income that needs to come into taxes. I can't pay X amount at the end of the year. At 55, and if you are receiving that exemption, you can pay your property taxes in installments. So that means you can break it down in a small chunk and pay it over a 12-month period, so you don't have to have that full bill due in January. If you decide to defer your taxes because of income or other reasons, you need to understand that those taxes will still accrue. They will still accumulate interest, and they will be due once that the qualifying event to defer the tax is removed. So in this instance, if the person that's 55 and older passes away, or they move from that house and that house is no longer their homestead, that deferral status will end, and those taxes will be due. Liens can still be placed on your property during the deferral period. The only thing the deferral stops is the enforcement of that lien. So Harris County or Fort Bend County can't come in and say, okay, you haven't paid your property taxes in 5 years or 3 years. We're going to foreclose on your property and we're going to put it in the auction. As long as that 65 and older exemption is there, they cannot enforce that lien. However, they can still place that lien on your property, meaning that once that exemption is removed, that they can foreclose on that lien pretty quickly. Okay, there's still a procedure they have to go through, but they can still foreclose on that lien and have that property auctioned off. Incapacity issues. Now, we've talked a lot about incapacity and folks not having capacity, whether that's from an accident or a medical situation. It is important for you to have those powers of attorney, medical powers of attorney, medical directives, as Michele discussed in her portion of this presentation. If you don't have these in place, you will not be able to do it during your periods of incapacity. You cannot sign contracts. You cannot make changes to your bank accounts. You cannot change your beneficiaries. So if someone passes away while you're in a period of incapacity and you've named that person as a beneficiary, well, because you don't have capacity, you won't be able to go in and do those things without having something like a power or of attorney. In some instances, you won't be able to make medical decisions for yourself, depending on what level of incapacity we're talking about. And so your medical care will be in the hands of someone else. So there's a better way to do it, and the better way is to designate someone you trust now, that you've had those conversations with, that if something should happen to me, these are my wishes. And in some instances, in your medical directives, you can outline some things that you'd like to happen. Do I want to be fed intravenously through a tube? Do I want to be resuscitated? Do I want to stay on life support? Some of those things can be designated. If I have to have hospice care, how do I want that care to be made? Do I want to just be given, some drugs to make me comfortable and pass naturally? How do we want to go about that care? Well, you can think about those things now while you have the ability to make your wishes known, and the way in which you do that are through some of those tools that Michele discussed. When you have bank accounts and safe deposit boxes, a lot of clients decide to keep their wills or their estate planning documents that Michele discussed in safe deposit boxes. A lot of my older clients tend to keep majority of their wealth in their home and in their bank. And so some of these bank accounts they've had this account for 20, 30, 40, 50 years. It's always been my wife and I on this account, but I have no idea how my account was actually set up, because it was set up so long ago. And there are some assumptions that I've made about these accounts. I've made assumptions that when I pass away or my wife passes away, that money will automatically come to the surviving one of us. That may not always be the case. So if you have a joint account without the rights of survivorship, meaning that account, rights of survivorship just means who's going to own it at death. Nobody has to do anything additional. At death, the other surviving person will have ownership interest in that particular, in this case, in the bank. So without rights of survivorship, you're just joint account holders. And so what will happen generally in that particular instance, if you pass away, or when you pass away rather, is that account, just think of it like this, that account will essentially kind of be split in half. One owner has one portion of it. The owner who passed away has the other portion. And then that owner's portion, the deceased person's portion, will be passed to those heirs. So if you have one of those situations where you have a blended family situation, it could get very complicated very quickly. So you want to be able to check in on a lot of these things while you have the opportunity to do so. If you have, and then one thing to remember is, in some instances, a lot of my elderly clients, their spouse may have passed away, so now they own this account, or they put the child or a niece or a nephew or someone who's caring for them, or who can go to the bank and run errands for them at the bank. They put that person on that account. So understanding what I've just explained to you, that a portion of that account will belong to the deceased person, a portion of that account will belong to the other account holder. That other account holder can deplete that account the moment you pass away, and now there's nothing left for your heirs. So if you've made plans in your will or your other estate documents to have that account go someplace, there's a better way to do it. So using some of those payable on death or transfers on death are probably going to be better. If you have a situation where there's some joint account situations, or you may want to plan differently now that you know some of this information. Joint accounts with rights of survivorship. The moment you take your last breath, that account no longer belongs to you. It then belongs to the surviving joint account holder. Payable on death and transfer on death. If you are the only person on the account, so the account is only in your name, payables on death or transfers on death account designations may be beneficial for your particular situation. If you're a joint account holder or there's someone else on that account, payable on death and transfers on death may not work for you. Most of the time, most banks do not do payable on death or transfer on death until the other joint account holder passes away. So that means whatever is in that account at that time, once the surviving joint account holder has passed away, that will go to your beneficiary who's been designated as a POD or TOD. Convenience accounts are those accounts where someone has the ability to make withdrawals, write checks, but they don't own any funds in that account. Now, they can still make those withdrawals and write checks on your behalf until the bank receives notification that you've passed away. Once you've passed away, that access that the person that was helping you with your account has immediately terminated. So you need to be careful if you have a convenience type of account. So think about your benefit for your benefit type of account. Once you pass away, if the bank doesn't immediately get notification that you've passed on, the person who has withdrawal capabilities can deplete that account and essentially leave nothing for whomever you've designated as a payable on death or on death on that. So if you're going to use a convenience type of an account, then you better make sure it's somebody you can trust and you know that they're going to do the right thing, even when they have the ability or the temptation to do something otherwise. So you'll want to make sure you plan for that. Again, going back to your estate documents, a lot of people like to keep their things in safe deposit boxes. It's not a bad idea. However, who can access your safe deposit box upon your incapacity or death? Well, if you are incapacitated, generally no one can access that safe deposit box if they're not also a joint owner of that safe deposit box. So if your name and your wife's name are on that safe deposit box account, then your spouse will be able to access that. If there is a will that is found in your safe deposit box, the bank will not release that will. They will take that will and send it to the court or send it to the clerk's office for that particular account. And then you will have to file appropriate documents in court to have that probated in court, and the court will receive that will straight from the clerk's office. If you and your spouse are owners of the safe deposit box, as I said, your spouse will be able to have access upon your death. If you are only named on the safe deposit box upon death, the order generally is the surviving spouse, parents of the deceased, any adult child or grandchild, and the executor of your estate can access that safe deposit box, but that executor has to go through the process that Michele described before in her presentation in order to be appointed the executor, and then the court will issue certain papers, whether that's letters of testamentary or letters of administration, and they will be able to take those letters to the bank and access the safe deposit box. And so you need to be mindful of keeping some of your estate planning documents in safe deposit boxes. It's not a bad idea. You just need to be mindful of it. Most estate planning attorneys do something where they have some document that lets your loved ones know this is where my originals are being kept. You don't want that stuff out just for anybody to see or somebody just to come across haphazardly, because we've run into issues where people have taken wills and forged signatures or changed documents because they don't agree with your wishes or what you've already planned out. So safe deposit box is a good idea, but just be mindful that upon incapacity, generally you have to have a guardian in order to access that safe deposit box, especially if it's only in your name.
Thank you for watching. If you would like to join one of our live sessions, then please go on Facebook, type in Momentum Men's Ministry, and like the Momentum Men's Ministry that has the gold M as its symbol. It will allow you to be able to get updated information daily or weekly about our live next session, as well as some encouraging information. So join us every Saturday at 7:30 a.m. Central for the TCWW Momentum Men's Fellowship. Also, watch us on Facebook, Instagram, or live.tcww.org for live worship each Sunday at 8 a.m., 10 a.m., and 12 p.m. Log on to thechurchwithoutwalls.org for all church events, announcements, and giving. Thank you for listening, and I pray you have a blessed day. In Jesus' name, amen.